You're listening to The Voice of Russia in London. I'm James Reinl, and we're taking a look at when murderous leaders end up behind bars. Take a look at this week's headlines, and it would appear that the wheels of justice for toppled autocrats are spinning faster than ever. Egypt is braced for more street violence as revolutionaries await the verdict and sentencing of their one-time dictator, Hosni Mubarak. The last major Balkans bogeyman, the so-called butcher of Bosnia, Ratko Mladic, is on trial in The Hague, and the former Liberian president, Charles Taylor, was caged for 50 years this week for aiding and abetting some of the worst war crimes in history. This was the first international tribunal to convict a former head of state since the end of the Second World War. It has also been hailed as signifying that the world is entering a new era of accountability. But is it? Take a look at Syria, where government-backed militiamen butchered 108 men, women and children in Hula last week. President Bashar al-Assad doesn't seem too bothered by a potential atrocities tribunal, nor, for that matter, did Libya's leader, Colonel Muammar Gaddafi. So, are we heading towards an age of impunity in which all state-level killers end up in jail? Or are these tribunals just another reason for murderous despots to cling on to the bitter end? And why don't civilian deaths in great power conflicts like Iraq, Afghanistan or Chechnya count as crimes? To probe these questions, we're hosting a discussion in our London studio. I'm joined by Dr Mohamed Elewa Badar, an Egyptian jurist from Brunel University, Juergen Schurr from REDERESS, which campaigns on behalf of torture victims, John Laughland, author of A History of Political Trials from Charles I to Saddam Hussein, and Sergei Strokan, a commentator for Russia's Kommersant newspaper over the line from Moscow. Okay, to get the ball rolling, I'd like to get a single-sentence answer from each of you to the following question. First of all, to you, Juergen, are the judges in the Taylor trial right that the world has entered a new era of accountability?
Well, I think the judges are right in saying that there is an era of accountability that has started with the establishment of international tribunals for Rwanda and for Yugoslavia, and that has seen its peak with the establishment of the International Criminal Court.
And to you, also in the studio, Dr Mohamed Elewa Badar.
I would agree and disagree. I would agree, yes, if you look for the past 2 decades after the establishment of the Yugoslavia and Rwanda Tribunal and other hybrid tribunals, I said yes, I would agree. But if you look at other massacres which took place and ongoing massacres like the one which took place in Darfur, Sudan, I have to say I disagree. We still need to set trials, for those criminals and perpetrators.
Okay, and you, over the line to Moscow, Sergei Strokan.
Both yes and no. Yes, in the sense that obviously this is a milestone in world affairs to bring all those international criminals to international justice. This is a leap forward. But at the same time, all of us have to understand that this is a process and this is an uphill battle. You can't just come to the triumph of international justice just in one day.
And John Laughland, same question to you. Has the world entered a new era of accountability?
Definitely not. This is a classic example of the sort of self-congratulatory remark which international judges and other supporters of international justice have been making now for more than 10 years, really, ever since General Pinochet was arrested in London in 1998. The fact is that if there's any impunity or immunity around, it accrues to the judges themselves. It's ridiculous to say that there's an end to impunity because the very judges themselves and the powers which stand behind these tribunals themselves enjoy the legal immunity which they deny to former heads of state. The fact is that all judicial systems are based on immunity at their apex, and by putting a head of state on trial as they did over Charles Taylor and as they've done over many other heads of states over the last 10 years or so, all they're doing is asserting their own power over these people, not the end to impunity as such.
Okay, thank you for your comments there. And now I'm going to put it back to Juergen Schurr in the studio. And maybe we'll stick with the Charles Taylor trial because obviously your organisation, REDERESS, is interested in the victims. So perhaps you can just give us an explanation for what Taylor exactly has been convicted of. What are the crimes, the atrocities that he's responsible for? And what does his sentencing mean for the people that have suffered as a result of his actions while he was in power?
We often see in these state-sponsored crimes or systemic crimes that victims do not receive any justice because they are being perpetrated by those up in the higher accolades of the state and the government, and which proceeds to protect itself by amnesty laws, by invoking immunities for themselves, etc. So we see that these trials and tribunals provide an opportunity for victims to obtain justice, and also with the ICC to also obtain reparation. And that is in itself a very significant step for victims to come to terms with what happened, because it's also, as now with the Charles Taylor case, an acknowledgement of the crimes that were committed by Charles Taylor.
Can I just jump in there? You used the phrase ICC. Now, just so that the listeners understand, the ICC is the International Criminal Court. That's the world's first permanent war crimes tribunal, and it's a bit of a complicated picture when it comes to these tribunals because there are lots of them. You mentioned there's one specifically in the case of Rwanda, another bespoke tribunal in the case of the former Yugoslavia, and the ICC is the first time there's a permanent one.
Yes, so what I was saying is that for the victims of Charles Taylor in Sierra Leone, this is an important signal that these crimes that he has been convicted of, aiding and abetting in these crimes, in the perpetration of these crimes, cannot go unpunished, and that these crimes do constitute a crime under international law, that victims do deserve justice and do deserve reparations. So this is an important signal. At the same time, of course, I fully agree that a certain amount of criticism is merited. The trial has lasted a very long time. The judgment phase itself has lasted a very long time, and the judgment is about 2,500 pages long, which of course in itself doesn't really contribute to advocating for the values of international justice within society, because it doesn't make the judgment really accessible to victims and the society at large.
Maybe I'll turn that one back to you, John Laughland. You seem to express concern that these kind of trials are politicised. In this case of Charles Taylor, what Juergen was explaining there is that he's clearly been convicted of atrocities, that there are many, many victims of these atrocities, and they need justice. Isn't that a fair and reasonable point?
Not at all. There are very few judicial systems in the world which give any role at all to victims. There are some marginal roles for victims in certain jurisdictions, but generally speaking, we regard it as barbaric for victims to play an active role in criminal prosecutions. It does happen in certain Sharia law jurisdictions where the families of victims and victims themselves can demand blood money for the wrongs that have been done to them. But I think many of your listeners would agree that this is the very antithesis of what we understand by a proper judicial system. It's one of the worst aspects in which international justice is showing itself to be a step backwards, that it does indeed, as Juergen says, allow a very strong role for victims. The reason why we like to limit the role of victims is precisely because if you give them an active role, then you are facilitating demands for revenge. In the case of the Charles Taylor trial, what is notable is that the prosecution failed to prove its main and original charges, which were that Charles Taylor had command and control over the forces in Sierra Leone which were committing crimes. Charles Taylor, I'd like to remind you and all your listeners, was not the president of Sierra Leone. When everybody says this is the first conviction of a head of state since Karl Dönitz at Nuremberg, this obscures the fact that Charles Taylor is in fact the first head of state, I'm pretty sure, to be convicted for his foreign policy. He was convicted for supporting rebels in a neighboring country. But by no stretch of the imagination can he be said to have command or control or any other command responsibility over what those rebels did. What we see in the Charles Taylor trial, in other words, is a classic example of the abuse of judicial process for political ends. The political end in this case being to get Charles Taylor out of Liberia, which was a stated goal of the American administration.
Okay, there's some pretty controversial comments there. Maybe I'll put that to you in the studio, Dr Mohamed. The claim is that the prosecution case against Charles Taylor wasn't adequately made and manipulating the use of victims in giving evidence in the trial.
If you ask a victim, whether or not that a judgment was delivered for 50 years sentence, apart from these political issues, I would say yes, at least now victims, can say yes, there is judgment, there is a justice has been delivered.
Okay, and maybe I'll put that one over to you, Sergei in Moscow.
I think we all of us have to agree that it is quite easy to criticize international criminal code for double standards, for biased approach, for other things. But we have at the same time to understand that there's no option, you see. If we just say that this mechanism is not working, if it is not proper, then we will face the situation where there will be no mechanism to bring to accountability those who are responsible. That's why, while saying what has not been done, we have to also say what has been done also.
You're listening to The Voice of Russia in London. I'm James Reinl, and we're taking a look at when murderous leaders end up behind bars. I'm joined by Dr Mohamed Elewa Badar, an Egyptian jurist from Brunel University, Juergen Schurr from REDERESS, which campaigns on behalf of torture victims, John Laughland, author of A History of Political Trials from Charles I to Saddam Hussein, and over the line from Moscow by Sergei, Strokan, a commentator for Russia's Kommersant newspaper. I'd like to throw it back to John Laughland at this stage. From what Sergei was just saying, is the conclusion of your argument that because a form of international justice is always going to be to some extent political, that we might as well not bother in the first place?
Yes, that is my conclusion. It's not true that there is no mechanism for bringing people to account. That mechanism is known as national politics. And for that matter, the national juridical system in each state where conflicts have occurred. Nearly all states have procedures for bringing senior officials and even heads of state to book in one form or another. If states decide, through signing a treaty like the International Criminal Court, to transfer these competencies to another organization, that is their right. But what is absolutely unacceptable is to have either ad hoc tribunals created by great powers to prosecute specific people, because that is completely incompatible with the very notion of the rule of law, or indeed for this International Criminal Court, which has received delegated competencies by treaty from certain states, to then charge around indicting heads of state and other officials of states which have not signed its treaty. These are quite simply illegal acts, and the ICC has quite flagrantly violated all possible terms of international law by indicting first the president of Sudan and then later Muammar Gaddafi of Libya. These are ultra vires acts, and frankly the Security Council resolutions which similarly created the special tribunals for Yugoslavia and Rwanda were ultra vires acts as well. We need to get back to an understanding of what law is and what the rule of law is. We need to understand also what legitimacy means and what the basic principles of constitutionality are. There's no good saying there are all these terrible atrocities going on, something must be done, because that is just emoting. If we're trying to put in place a legal structure, then it has to be based on proper rule of law principles and on constitutionality. And all these tribunals, in their different ways, violate those fundamental principles.
Just picking you up on one point there, though, you're saying that the actions by the UN Security Council in this respect were illegal, but isn't that totally the wrong way round? That anything that is authorized by the UN Security Council is the ultimate arbiter. It's the highest court in the world.
Absolutely not. That is a very, very severe misunderstanding. There is no institution in the world which has the power to do whatever it likes. The United Nations Security Council's powers are laid down in the Charter, and there is nowhere in the Charter any hint that creating criminal jurisdictions is part of its peacekeeping operation. Moreover, there is a huge body of international law which declares illegal, including the Charter itself, any form of intervention in the internal affairs of other states. Now, as I say, if people want to change this, if they decide that, no, we don't want to have national sovereignty anymore, we all want to live under one world government, or at least pool a lot of our resources together in regional or other arrangements, they can do that by treaty. But that's not what is happening at the moment. We have, on the one hand, ad hoc tribunals illegally created, and on the other hand, we have the ICC, which has immediately overstepped its powers.
I'm going to let Juergen get back in there because I know he wants to comment on a lot of what you just said there, John.
I would actually like to start with the role of victims, being only in very few countries that victims play a role in the criminal justice system, which of course is absolutely not true. If you look at civil law countries, which are a large part of the countries in the world, have a civil law system which expressly provides for victims to play an active role in criminal justice procedures. Victims can bring a claim for compensation, for example, within the criminal proceedings under national law. That's the case in France, Belgium, Germany, and many other countries. So that is clearly one thing that has been taken up by the ICC, which now allows for victims to also play a role before the ICC.
I'm sorry, but you just said that we're allowed to sue people for compensation.
Within the context of criminal proceedings, that is exactly right.
What you are talking about in international tribunals is a specific role for victims in the process of criminal procedure, not in the process of litigation seeking compensation.
And that process is entirely fair, as we can see before the ICC.
I'm well aware that, for instance, Germany allows a limited role for victims, even in criminal cases, and maybe other jurisdictions too. What I'm saying is that that role is excessive in international tribunals, and it's the prominence given to victims by lobbyists such as yourself and by the tribunals themselves fuels the flames of a desire for vengeance. because a criminal prosecution should be carried out by the legally constituted authorities of the state and not by individuals. That's how people keep a limit on the desire for vengeance.
Obviously, we disagree very much on this, but we can see that the ICC guarantees a fair trial for the accused by allowing all the rights for the defense, for the prosecution, and by allowing victims to participate in proceedings. We see that by a dismissal of arrest warrants. We see that by dismissal
whether or not
of
somebody is a victim. So it is a structural flaw to introduce someone into the courtroom and say, right, here's a victim, because that is begging the question. That is exactly what a criminal trial is designed to decide.
You're listening to The Voice of Russia in London. I'm James Reinl, and we're taking a look at when murderous leaders end up behind bars. I'm joined by Dr Mohamed Elewa Badar, an Egyptian jurist from Brunel University, Juergen Schurr from REDERESS, which campaigns on behalf of torture victims, John Laughland, author of A History of Political Trials from Charles I to Saddam Hussein, and over the line from Moscow by Sergei, Strokan, a commentator for Russia's Kommersant newspaper. Now, I'm going to turn to Dr Mohamed now. I'd like to move on to a different case, and this is a case that's happening in your home country, Egypt, over this weekend. We're expecting the sentencing and the verdict in the case of Hosni Mubarak. He, of course, was the president of Egypt until he was toppled by the revolution. Can you just give us a quick update on what he's actually going to be sentenced on over the weekend and what you think about that case?
This is the first trial of a former Arab head of state in an ordinary court of law, in which the defendant has personally appeared in court since waves of street protests. I would like also our audience to know that it's only a trial for crimes committed or being committed during 6 days from the 25th of January 2011. It doesn't deal with, again, what happened for the past 25 years or 30 years. Again, we have something like mass torture, and other crimes committed by state security of Egypt.
And that's a problem for you?
Of course, it's a problem, but at the end of the day, of what happened actually in the 6 days or 7 days revolution. But what about people being in jail, for 3 or 4 years without due process, being people tortured and murdered? So again, maybe it is a first phase, but what about the other phases? No one should decide on that, because we also are waiting for the new president and a new constitution. And we see also the parliament, they have to say, yes, they are paralyzed. Even if they want to issue new laws or whatever, still the parliament is paralyzed. We are waiting for the constitution. Let's speak about the death penalty. The death penalty or the life imprisonment, again, is not the end of the trial, because, again, we have the court of cassation. So, as a defense, you can appeal, but we don't have appeal court for felonies. We have something called court of cassation. So it's not like it's the end of the story. It can be, yes, he's sentenced now for 25 years or sentenced to death, and all of a sudden you find, yes, the Court of Cassation will acquit him or ask for a new trial.
Okay, maybe I'll put that one over to Sergei in Moscow. What do you think about the Mubarak sentencing? Because we're talking about a case here which is a bit different to the Charles Taylor case, because in the Egyptian case, it's being handled by a national court rather than an international court. And that was one of the big distinctions that John Laughland was drawing. Sergei?
That's right. Really, this is the attempt to settle the issue within the framework of national Egyptian legislation. And as I understand, a bit the irony of the situation is that while just putting President Mubarak on trial, Egyptians now face the situation when probably they will see the revival of President Mubarak epoch. Let us be frank. Those who put President Mubarak to jail, they wanted to go ahead with some sort of trial of history. And while he is charged with corruption, with embezzlement, as well as giving orders just to kill peaceful demonstrations, at the same time, this is just an attempt to close the page of the history which is associated with the name of Hosni Mubarak. But at the same time, ironically, this trial coincided with presidential election. And as you know, Egypt is facing the second round of presidential election. And one of those who are still fighting for president chair is one of the close associates of President Mubarak. I mean, ex-Prime Minister Omar Shafiq. So the irony of the situation is that while trying to denounce the legacy of Mubarak, Egyptians probably will come back to this epoch. Because if you just compare what happened into Egypt now and over the time of Mubarak, You may say that that was authoritarian rule, that there was a lot of corruption and other things, embezzlement, nepotism, whatever. But at the same time, the major output of the country, like foreign investment, tourism, that was all on the rise. And now we see dramatic decline. So this is the irony. What sort of court of history is it?
I want to put that one over to John Laughland, because this is an important point that's being raised here. You earlier spoke of the fairness of national jurisdiction. You supported national courts, and you said that international courts can be politicized. But here's Mubarak, here's a case of a national court, but as the other guests are saying, it's happening at the time of a presidential election. It, of course, is also going to be politicized.
What I said was that international courts pose a particular constitutional problem. The constitutional problem which they pose us an additional problem, because they, unlike national court, not being embedded in the structures of a state, they never respect, structurally speaking, any of the engagements which form part of the social contract. What I mean by that is that the reason why a state has the power to use violence against people, to imprison them or to punish them in one way or the other, is that a state is part of an overall system of government which, in return for this power, which is unimpeachable legally, and which is a considerable power, offers protection to its citizens. International tribunals break the social contract at the most systemic and fundamental level because they have no governmental power over any territory. They have power over territories. They can indict state leaders and other officials of countries, but they never bear any of the consequences. So they pose an extra additional problem. However, it's entirely right that we should be talking about national prosecutions of leaders as well, because the general issue of politicization of these trials applies equally to national trials as to international ones, because what they all have in common.
I would like to intervene here and again to say to my colleague, but again, when you speak about international criminal tribunals with all the logistics they have and all these funds they have, if you look at the Egyptian situation now and what the prosecution during Mubarak trial said, that the prosecution said the Minister of Interior and other state intelligence, they were actually reluctant to provide any material evidence, so the prosecutions themselves, they went to the street, they went to investigate it themselves. Again here, with international criminal tribunals, all this logistics, this would never happen. So again, if you go...
That's absolutely not true. I strongly disagree with Juergen Schurr, who said earlier that international criminal trials are fair. I'm a very strong critic of them. They're not fair by any chalk. And I would go further and say that they have been guilty of committing torture themselves. I wonder if redress will inquire into the case of Vojislav Šešelj.
And is it fair to have 1,000 civilians killed without having material evidence from the Minister of Interior? And the trial will go, and the trial went without any material evidence, from the Minister of Interior, because they themselves were the perpetrators. And state security...
You've interrupted me, and perhaps you don't know what I'm going to say about
please,
national trials.
For that.
My point is that these trials, these regime trials, are, in my opinion, just as unfair at national level as they are at international level. So if you're telling me, and you know that you're much closer to this than I am, that the trial is unfair or biased or perverted in one way or another in Egypt, that doesn't surprise me at all. Because in the book that I've written, which deals with the criminal trials of all heads of state since Charles I of England in 1649, I've come to the conclusion that all these trials, without exception, are in one way or another seriously flawed and basically examples of political justice. And the reason for that is that it is not possible to bring a 30-year regime under the ambit of the criminal law. The criminal law simply, as a matter of historical fact, breaks down under the burden. And that, I'm afraid, is, I believe, a conclusion that it's impossible to avoid when you look at the history of these trials. Now, it may be desirable either that you have a trial or that you have an amnesty, but these are political issues, and one way or the other, they have to be decided politically. And when instead the criminal law is given the task of deciding which path to choose, then, I repeat, the criminal law breaks down.
And what does that mean, deciding these things politically? And maybe you could speak in terms of specific examples, like Charles Taylor or Mubarak.
I'm generally speaking, but I mean, obviously each case is for people to decide. But in my view, we should get back to a tradition, which was indeed a strong tradition, of amnesty. There has been a huge inflation now in these trials. My book came out in 2008, and about 10 former heads of state have been put on trial since the book came out. There'd only been about 30 in 300 years when it was written. So there's been a huge acceleration, and now the default position, whenever a government is overthrown, is for there immediately to be a criminal trial. This is a bad development.
We're going to have to wrap it up now. Maybe I'm going to get Juergen back in here. The idea of an amnesty proposed by John Laughland, there is a lot of sense in it. Take, for example, the case of President Saleh in Yemen. Part of the reason that he was able to get an exit and there was allowed to be some political solution to that country was because the Gulf Cooperation Council and negotiators who were striking the deal said that he could get off without fear of a prosecution. Perhaps President Bashar al-Assad of Syria would be more willing to forego power if he knew that he wasn't going to end up in a courtroom in The Hague. Maybe Colonel Gaddafi of Libya would have been more willing to give up power if he knew that he wasn't going to end up in the dock. Isn't there a case for this?
Well, I don't think there is a case for this. We don't have any evidence supporting that amnesties would contribute to the building of a democracy after conflict. To the contrary, we see that impunity, which basically is guaranteed through an amnesty law, fosters further crimes on a large scale. We see that, for example, you referred to the Syrian case. There is no immediate threat for the president to be taken to the Hague, because we see that in Russia, for example, there is a great reluctance to refer the situation to the ICC. So there is no immediate threat for him to be taken to court.
Sure, but he's got all the cards when he's president, and he loses all the cards when he stops being president.
Well, but that doesn't stop him from committing crimes on a large scale. There have been massacres over the past couple of days in Syria without a threat. And our position would be that the impunity that he has at the moment only fosters the commission of these crimes, whereas an accountability process before the ICC or another mechanism would actually contribute to accountability and to the establishment of rule of law.
And has that worked in the case of Gaddafi or Bashir of Sudan, who are both under indictment by the ICC? Where's the deterrent effect there?
Well, obviously, al-Bashir isn't even arrested yet. So all the states that are a state party to the Rome Statute are under an obligation to arrest him and take him to the ICC. And we can then see whether, once he is being indicted and possibly convicted, who knows, whether or not that had a positive impact on the situation in Sudan. But we see as long as he's there and there is no accountability process, he can continue committing these human rights abuses.
I have to say it's one of the saddest developments of modern times that organizations that portray themselves as NGOs, as I believe is the case for Redress, are in fact nothing but mouthpieces for government propaganda, particularly Western propaganda. If I were running an NGO campaigning against torture, I would be speaking out now strongly against the Syrian rebels, who are credibly accused of very serious human rights abuses. Instead of which, all we hear from Juergen Schurr is exactly what we could hear from the spokesman of the Quai d'Orsay or from the British Foreign Office.
This is entirely
Your
not the case.
organisation is funded by the European Commission, and you are behaving like a sock puppet for the Western government.
And
I think if you want to be credible in the ears of your listeners, then you should analyse
Okay, don't talk over each other.
objectively.
Okay, that was John Laughland, author of A History of Political Trials from Charles I to Saddam Hussein, arguing that these international tribunals are really just a case of victor's justice. I was also joined by Dr Mohamed Elewa Badar, an Egyptian jurist from Brunel University, Juergen Schurr from REDERESS, which campaigns on behalf of torture victims, and over the line from Moscow by Sergei Strokan, a commentator for Russia's Kommersant newspaper. You're listening to The Voice of Russia in London. I'm James Reinl. Stay tuned for the latest update of what's making headlines around the world.